Good afternoon. It's a Wednesday. It's December 27th. It's a random live stream. Replay crew, love you. Everything will be timestamped down below. For those of you that are short on time, this will probably be clipped down on the Quick Bits channel. And if you're wondering, Emily, I didn't know you were going live. That means you need the Law Nerd app at lawnerdapp.com so you know when I am going live. Today, we are covering Jodi Hildebrandt's guilty plea. Her lawyers had given no information to the media ahead of her court hearing today, but we saw Ruby Franke plea like a week and a half ago. We knew this hearing was scheduled today for the same thing, a preliminary hearing waiver. It was likely that this plea was going to come. We've seen Kevin Franke say that this was all Jodi Hildebrandt's fault. I have thoughts. We've seen Ruby Franke say that she's going to testify against her co-defendant, and this is all Jodi Hildebrandt's fault. So Jodi Hildebrandt was coming up to court today, knowing that the co-defendant that just pled guilty and agreed to prison time was going to testify against her. She did not have a lot of options. We're going to cover the court hearing and the video from that very short court hearing today. It was like maybe 4 or 5 minutes long. We're going to cover that hearing, and then we're going to do a lot of questions. I know you have a lot of questions. I've seen them in the comment section. I've seen them all over the comments on these various videos and podcast episodes. So I'm going to try to answer the questions that you have been asking across my coverage of this case and try to explain some of the things. I've seen a lot of questions about, whether Jodi really is a first-time offender and what that even means in the context of a criminal case, if these women are going to prison, things like that. And I'm going to answer those after we cover this hearing today. So thank you for joining me on the random live stream. Thank you for all the love for the app. I know that's how most of you got here, and we're going to just get going. So Law Nerd, thank you for being here. I hope you're having a happy holidays. We were going to be off all week, but now we're here. So let's just get into it, shall we?
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not... Let's get into it.
Y'all, first, before we get into anything else, to all of you that have gifted memberships, absolutely thank you. Eric gifted 50 memberships. B2 is in the chat gifting memberships. And we have new folks gifting memberships. We've got Debbie W gifting memberships. And we've got Natalie C gifting memberships and Light Chaser gifting memberships. Thank you all so much for gifting this community. You guys, let me know where you're coming in from. We're going to give a quick road so far, then we're going to go to this hearing, and then we're going to go to Q&A. Just one topic today. There is a factual basis plea. I am not going over the factual basis affidavit. We know that it's going to be horrific. We know that it is child abuse. So I am not going to get into the details of that. You will be able to find that all over the internet. And I don't think it's helpful to talk about the law in this case. I don't know if it answers the legal questions that we need answered. We know that it's bad. We can leave it at this is really bad and they will go to prison for this and not get into every single detail of how these children were abused and tortured. And so I just am letting you know, we went through a little bit of the factual basis on Ruby Franke. It's going to be largely the same. Don't need to get into it. I also really have tremendously appreciated how many of you have shared that covering content the way I cover content makes it accessible to you, where these topics might be a little too much. Even knowing that it's bad might be too much for some of you, but knowing that we can go through the court hearing and we're not going to get into details allows this to be accessible. And I really appreciate all of you sharing that that's helpful for you, that it makes it opens up the ability for you to be able to engage in cases like this that are so very difficult, and understand the law without having to parse and navigate all of the details of the horrific things that have happened here. So thank you for all of you that continue to share that makes content accessible to you, that we are able to cover this without sensationalizing in any way. It is a very sad case. It doesn't need to be made anything other than just covering the legal, but I know there's going to be a lot of questions, and I wanted to answer the questions for y'all because I thought that would be helpful. So we're going to Utah today. I have a hair that's just stuck to my lip gloss. So, it is what it is. Eventually I'll get that off of my lip gloss, but it is. I got a new hair dryer. I was trying to do the things, and now I can't be an adult. This is why we can't have nice things, Emily. Okay, so with all of that, it's so good to see you guys coming in from all over the world. I appreciate you. Thank you. Good to see you. It always blows me away a little bit how many of you come in from not just all over the states, but truly all over the world. I saw the Philippines representing earlier, and just all over. It's so good to see you. And I do this because I like having conversations with you. So let's do a quick road so far. When I swoop, will I be able to get this hair out of my mouth? No, it's just, we're just having streamer issues today. Ha, I think I got it. I think I got it. All of you. It's so good to see you. All right, law nerds. Let's go. We had to say hi to Canada representing, Australia, just y'all. Law nerds, y'all are international, which is why you make this the best place to watch court coverage. Let's do a quick road so far, shall we? Let's just do a catch up. Today in court, Jodi Hildebrandt was on the docket to waive preliminary hearing. She is the co-defendant of Ruby Franke. Both Ruby Franke and her estranged husband, because they're in the middle of a divorce, Kevin Franke, have said that Jodi Hildebrandt is the problem, that she is the one that is behind everything that has gone wrong in their lives. And in a statement lawyers made public that I covered on the Emily Show podcast, Ruby Franke said that she was led astray by Jodi Hildebrandt. I have a lot of thoughts on whether you can be led astray into abusing one's own children, but that's for a different episode, and I've already gone through it. So Jodi Hildebrandt, they have said, is the mastermind. She is the one that Ruby Franke partnered with when they stepped away from the 8 Passengers YouTube channel and were getting into being parenting influencers, teaching other people how to parent, which makes all of this even more horrific, given that we know Jodi Hildebrandt and Ruby Franke have both pled guilty to horrific child abuse. Ruby Franke will be sentenced on February 20th. Jodi Hildebrandt will also be sentenced to February 20th. Both women have pled guilty to the same counts. Both women have agreed that this will be a prison term. The judge will determine the sentence. We're going to go to this courtroom, same judge, different courtroom today, with footage from Court TV, and just break down what happens in this court hearing. It's about 4 minutes long. It really is a waiver of rights, an agreement to factual basis, and guilty pleas. But we have not seen Jodi Hildebrandt in court in person because of how this case stalled. Remember, this case came about because one of the young children victims escaped and ran to a neighbor asking for help. That neighbor called 911 in a chilling call where the neighbor is clearly trying to process not just the physical state of the child, but what the child is telling them, and get 911 to come and help. After that, Ruby Franke and Jodi Hildebrandt are arrested. They both immediately ask for expedited bail hearings and then take those off calendar. And then there was discovery motions and nothing else has happened. So this case from the time of arrest has been in court once for arraignment, and that is it, and is now back in court for change of plea that was supposed to be a preliminary hearing waiver. My thoughts on this: the children aren't going to have to testify in this case because now both co-defendants have pled guilty. And at the end of the day, I think that that is a tremendous benefit to these young victims to not have to go to court and testify. And we will talk about that a little bit more after we watch this court hearing. So let me go ahead and pull that up and we will get into this court hearing today. So law nerds, this hearing does not cover the details of the case. It's just going to cover the plea and the waiver of rights. And that's what we're going to hear now. Once I pull it up. And what I love is because we've got this from Court TV, we've got closed captioning on, which is always helpful. Let's see if we can do that. All right, let's roll. Oh, I should swoop. Emily, swoop. Do the things. Let's go to court.
here this morning in the matter of State of Utah versus Jodi Hildebrandt, case 231501763.
I've got this gained up as much as I can, but audio out of court is coming in mono. So if you only have one headphone in and you're like, why can't I hear? That's because the court is coming into the feed on one channel, which is always somewhat annoying, but it is what it is.
3. Mr. Clark and Mr. Sham are here representing the state of Utah, and Mr. Terry is here with Ms. Hildebrandt.
Was it the attorneys?
We are scheduled for a waiver of preliminary hearing. Mr. Terry, it appears you have just handed the court a signed plea agreement.
That is correct, Your Honor.
This is Co-Defendant Jodi Hildebrandt's defense attorney handed up a signed plea agreement. So though this attorney chose not to say anything to the media ahead of this court hearing, they had a signed plea agreement. Again, it's going to look a lot like the signed plea agreement that we saw from Ruby Franke with everything laid out.
With respect to the waiver, Ms. Hildebrandt, we have had discussions. She fully understands the purpose of a preliminary hearing, what the burden of proof would be, and that she has the right to a preliminary hearing, but in conjunction with the entry of her plea today, we waive the preliminary hearing.
No preliminary hearing needed.
In the written plea agreement.
No prelim needed because she's pleading guilty and admitting guilt. No trial, no prelim.
That operates as a waiver of a preliminary hearing. All right. Ms. Hildebrandt, I've been handed a written document, a plea agreement with your signature on it. Did you sign that document?
Yes.
And you did that to represent to the court that you have read the document carefully, that you understand what you've read, that you agree to all of the terms that are set forth in that written document?
Yes, sir.
You've had sufficient time to ask Mr. Terry any questions that you have about the agreement or its potential effect?
Yes.
Is anyone pressuring you to enter into this agreement, or is anyone promising you anything that I haven't been told about or that is not in the written document?
No.
Are you under the influence of alcohol or drugs today?
No.
Is there anything today that could interfere in any way with your ability to understand the agreement, its potential consequences?
No.
No physical condition, mental health, or emotional condition, nothing that could interfere with your present ability to evaluate the agreement and decide if it's what you're prepared to do today?
No.
You don't need...
These are all standard waivers. The judge will take waivers like this in every case where there's a plea because there are a lot of constitutional rights attached when you are facing the loss of liberty and being, put into prison. So this is all standard waivers. There are also written waivers. So asking if you're under the influence of drugs or alcohol happens in every single plea deal. So all of these are very standard, very routine legal waivers. So there's nothing unusual. This is literally what judges do day in and day out on every case that pleas. Making sure that nothing's been promised to people outside of the written agreement that they have. So it's not, I'm pleading because somebody's, I'm under duress or I've been promised these other things that I'm expecting. None of that. It's all very routine at this point.
More time, you're ready to go.
Yes.
Any further record, counsel?
Your Honor, the agreement contains a factual basis. There are a few details in the factual basis that we are not in full agreement with. However, this is a guilty plea. It is not an Alford plea. The factual basis sets forth facts that we agree with, that Ms. Hildebrandt agrees with, that are sufficient for the court to accept her plea with respect to the 4 counts to which she is pleading guilty. And so we ask the court to accept her plea agreement.
What the defense attorney said is that there are a few facts that they disagree with in the factual basis. I imagine this factual basis is very similar because it is the same operating facts that happened in Ruby Franke's case because they are co-defendants. So same victims, same course of conduct. So she is not saying that she didn't do these things. Her lawyer is just saying they don't agree with every single detail of the factual basis. A factual basis means that she is agreeing that these things happened. So she is not just admitting guilt, but admitting guilt and admitting to all of the facts that are listed in the plea agreement. So that's what a factual basis is. And that is him saying, though we disagree with a few things, we are not taking, an Alford plea or a no contest plea where it is saying, hey, we're admitting guilt so we can move on, but we don't admit to all of the underlying facts. It's not that.
And apart from what is in the written factual base in the plea agreement, you have, I'm assuming, reviewed voluminous discovery. You don't dispute whether there is an actual or an adequate factual basis.
We do not.
The court clarified you're not disputing that there's an actual adequate factual basis. The court is clarifying, so there is enough facts for this defendant to say they are guilty of these crimes. And the defense said, we are not disputing that.
All right, then. Anything else before the court receives Ms. Hildebrandt's pleas?
No, Your Honor.
Nothing for the state, Your Honor.
Then, Ms. Hildebrandt, how do you plead to count 1, aggravated child abuse?
It's like the camera person hasn't been in court. The court is going to say this, and then it's going to go back to her. You don't need to swing it. So we're now going to hear which counts she is pleading to. I believe it is, she is pleading to 4 out of the 6 counts, same as Ruby Franke. We'll talk about that when we get to Q&A, but these are the counts she's pleading to.
Is a second-degree felony.
Guilty.
And to count 3, aggravated child abuse, a second-degree felony.
So 1 and 3.
To count 5, aggravated
Probably
child
5 and
abuse, a
6.
second-degree felony.
Guilty.
And to count 6, also aggravated child abuse, a second-degree felony.
Guilty.
The court finds that
Same
there
counts
is
as
a
Ruby
sufficient
Franke.
factual basis. The court, in addition, finds that Ms. Hildebrandt's pleas are made knowingly and voluntarily. The court therefore accepts and enters those pleas, dismisses the remaining 2 counts. We are anticipating a PSI, although part of the plea agreement appears to be that Ms. Hildebrandt will not contest a prison sentence.
Correct.
Is that right?
That is correct. But
Here's what matters. They're going to do the pre-sentencing investigation, pre-sentencing report, where the probation department and the Department of Corrections will determine a range of sentencing to advise the judge on, and will go through their background and compile that report. But both defendants in their pleas have agreed that they will not contest that a prison sentence is what's required here. So they are both agreeing that they will not fight that this is a prison sentence, because this is a prison sentence.
we are asking for a PSI.
All right, then the court orders the preparation of a pre-sentence investigation report and sets sentencing at 10:30 a.m. on February 20th. Anything else for today, counsel?
Nothing from us, Your Honor.
Nothing from us, Your Honor.
All right, thank you. We'll be in recess.
That's it.
Thank you, Your Honor.
That is a complete, absolute complete plea hearing. What, 5 minutes? We have covered a lot of cases on this channel where you have seen court hearings take substantially longer than this. This is more typical of what happens in a courtroom. This is more typical of day in and day out court operation. The attorneys talk beforehand. They know what's going to happen. They put it on the record in front of the judge. There is no surprise. There is no soliloquy. The factual basis isn't put on the record. It's not read into the record for an hour. It is on the written documents. Those are filed on the public docket, and that is it. The sentencing hearing might be a little bit longer because there may be impact statements. There may be written impact statements. That will be a different thing. There will be 2 sentencings on February 20th. So those might take a little bit more time. The attorneys might make some argument because ultimately the judge will set a sentence. But at the end of the day, this is very normal in how court operates. So with all of that, we're going to get into your questions because it's time to get into questions. because there's nothing else to happen in court. If later on there are more of you in the chat and we need to rewatch this, we can, but this is up on Court TV's YouTube channel. I will put, if I have a different angle of the hearing later from the pool camera, I will put that up and make that available to y'all as well. But this is it. So we're going to talk about what expected sentencing looks like and go from there. So let's get into Q&A, shall we? It's time. You guys have a ton of questions and I'm really excited to see it. So, because I hope it helps everyone understand the court process a little bit better. So with this plea, both women, Jodi Hildebrandt and Ruby Franke, have agreed that they will go to prison. How much time they will get in prison will be determined by their pre-sentencing report, investigation report, and by the court. Both of those, these women pled to the same amount of counts. Let me go pull up this document. But they both pled to the same amount of counts, which means they are going to be facing the same potential minimum maximum sentence. Their minimum looks like it's going to be 4 years. What I didn't see that I'm going to go look for in the court docket as we're doing this, because it wasn't available when I started streaming, but what we're going to pull up in the court docket to look is that Ruby Franke's plea very specifically says that each count will run consecutively, meaning each count will run after each other. So I want to go see if Jodi Hildebrandt's plea says the same thing as Ruby Franke. But what we know from the Matrix and Ruby Franke's case is that each count covers 1 to 15 years. They agreed that that would be consecutive. So the minimum would be 4 years, but it could be more than that. Of course, it could be up to 60. I don't think we will get anything close to that. I would be surprised if we even got into the 15-year range. I saw a number of you ask why these are second-degree felonies. The way that felonies are structured in different jurisdictions vary greatly. I don't practice in Utah, but oftentimes first-degree felonies are reserved for things like homicides, things like attempted homicides, and in those realms, there are generally some child abuse charges that fall in there. These are aggravated child abuse charges that are being pled with causing serious injury, but not also being alleged with a great bodily injury allegation and things like that. So there's a lot of in and outs we could get into about the way the legislatures write the laws, the propriety behind writing laws that are not so specific so they can never be prosecuted because they have to fit very specific fact scenarios versus cases that are, or laws that are written in a way that they encompass more behavior so that they are that people can be prosecuted under them. Hyper specific laws make prosecuting people beyond a reasonable doubt very difficult. So there is also a range, and I've talked about this in other coverage of this case. There is a range on this because I hate talking about this because it makes me so sad, but are these allegations horrific? Yes. Are these the most horrific allegations of abuse that I've ever seen? No. Are these the most horrific allegations of abuse this judge will ever have seen? No. There is a range of harm that is done. On the spectrum of range, this is not the top of the top of the top. These are also not repeat offenders. I know that some of you are going to take issue with that, and I understand. But I have not seen anywhere where Ruby Franke or Jodi Hildebrandt were criminally charged with these types of allegations before. So it doesn't mean that there aren't stories of them causing harm before. It means that they were not charged and prosecuted with harm before this. It means that they do not have prior convictions for similar behavior. It doesn't mean that they have never did anything. It means that they don't have a criminal history for this. So hopefully that makes sense when I say that they are, this is their first time with this. It doesn't mean that there aren't other allegations. It means that there's not been other prosecutions. And that is something that is very frustrating to many when you look at the fact that people have been complaining about things they've seen in YouTube videos for a substantial amount of time, that this is the first time this has come through court process with an arrest and a prosecution. That said, they do not have prior convictions for this. These are their first time, which means they are going to not get the maximum sentence. It would be either of them getting in that 15-year range would be sadly surprising to me, but they might. Should they? Yes. Will we see what happens at sentencing and what the pre-sentence investigations say? Yes, we can. And we will wait and see what those have to say. But each court generally has a way that they sentence things so that sentencing is consistent across the state. And that's something that we will see here too. Will the public ever hear about the custody arrangements? Maybe not. Those are all through sealed court unless one of the lawyers talks about it when it's done. Frenchie Taylor says social work here. The things we see are sometimes out of your worst nightmare and then more. Absolutely agreed with you, Frenchie Taylor. Thank you for the work that you do. Please take care of you. 15 years is total per count. Yes, it is total per count. So yes, in theory, the max is 60. Are they going to get there? No, I'm just trying to moderate expectations. Lori said, why sadly, Emily? I lose objectivity when it comes to harming kids. So my brain goes to all. Like it just goes to all. And I know a lot of you are there too. So it loses objectivity in I don't even think they'll get the max on one of these counts because that is what the court is more likely to do. I'm open to be pleasantly surprised, but I'm also trying to make sure that we have realistic expectations and make sure that there is realistic expectations. But I struggle with objectivity. But they did both plead to 4 counts of aggravated child abuse. That is definitely worthy of a sentencing up in the 10-year range. We will see what happens. I am just trying to moderate expectations. I'm going to try to pull up the court docket real quick while we're talking and answering questions because I very much want to see if the consecutive is pulled out the same way it is for Ruby Franke for Jodi Hildebrandt, which means I have to fight with this court captcha. I'm a human. I'm streaming live. I'm not a cat. I hate those things. I hate captchas. They're not always easy. Which probably says something about me, but I hate them. Okay, now that I'm into the docket, let's see if this is up. Yes, it is. Waiver filed today. So this should be that full document. Let me download this. All right, let me take a look. It's so strange because this one looks entirely different than the Ruby Franke one. Here, just on a practical matter, these 2 documents look very different. This is just the docket. That's why. All right. This is just the minute order. Let me cover the minute order real quick. And then if we get the rest of it, I'll pull it up. Defendant waives preliminary hearing. Court orders defendant held to be answer on the charges listed. PSI ordered. Plea agreement was reached. Defendant pleads guilty. Counts 1, 3, 5, 6. Counts 2 and 4 are dismissed per the plea agreement. Factual basis found as stated in the agreement and pleas entered. Pleas are made freely, knowing voluntarily. Pleas are accepted and ordered by the court. Sentencing February 20th. So this is not yet. This is the minute order, but this is not the guilty plea. Let me see if this is it. All right. One more document. There we go. This is the right one. Those are fast. Damn, Utah. Way to get it up there quickly. All right. This is the guilty plea document. I'm not going to go through the factual basis. I am going to look to see if there is a note that these are concurrent. To those asking why counts are dismissed, I'll get to that in just a second. So a lot of you asking about that, and I will get there. I will get there after we pull this up. Let me see. Sorry, as I'm looking between my two monitors to make sure this pulls up while I'm talking about it and that you can see it. Emily, it's like you haven't streamed in 3 days. Get it together. All right. So we see the same matrix that we saw in Ruby Franke plea. This is for Jodi Hildebrandt, counts 1, 3, 5, and 6. Those are the counts that were pled to. Second-degree felonies, 1 to 5 years in prison. The charges, that's the factual basis. Waiver of constitutional rights. This is the same waivers. Consequences of guilty plea, potential sentencing, maximum sentence may be imposed. I know that by pleading guilty to a crime, it carries a mandatory penalty. I will be subjecting myself to serving the mandatory penalty for that crime. I know my sentence may include a prison term, fine, or both. I know that in addition to a 90% surcharge imposed, that's about the restitution pleas. Here's the plea agreement. My guilty plea is the result of a plea agreement between myself and the prosecuting attorney. All the promises, duties, and provisions of the plea agreement, if any, are fully contained in this statement. Defendant agrees to plead guilty to count 1, 3, 5, and 6. The state will dismiss counts 2 and 4. Defendant will submit to a PSI. Defendant agrees to serve a prison term. The sentence received for 1, 3, 5, and 6 are to be served consecutive to each other. That's what I was looking for, meaning that the court could sentence Jodi Hildebrandt to 4 years minimum and then up from there. So this is a consecutive sentence, not a concurrent. Consecutive means that they add. So if it's 1 year for each count, it's going to be 1, 1, 1, 1 to 4. If it's 5 years for each count, it'll be 5, 10, 15, 20. 3 years, it'll be this, 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 and that. So consecutive counts. The counts that were pled to are counts 1, 3, 5, and 6. Those are the same counts that Ruby Franke pled to. All of those counts are aggravated child abuse, 2 counts for each victim. So same counts. So that is the plea agreement we have gone over. Let's get back to questions real quick. I'm glad it's consecutive. I'm glad they agreed to prison. The only thing not in Jodi Hildebrandt's plea agreement that we saw in Ruby Franke's was the agreement to testify the co-defendant against the co-defendant. So there it is. So which one will serve more time? I don't know. Maybe they will both get the same amount of time. They've both pled to the same stuff. Let's see. Yeah, this is the same, largely the same factual basis. I would have to go through line by line, but this is largely the same operative facts for what was done to each kid. So I can see them getting the same amount of time. And yes, this case is in front of the same judge. I have not taken a look at whether this is an 85% case or a 50% case in Utah, but I will take a look before we get to the sentencing. So what didn't they plead to? They didn't plead to all 6 counts were aggravated child abuse counts under different subsections. So they didn't plead to 2 counts of child abuse, of aggravated child abuse. So I covered that a little bit more in the others. What are the counts? Counts 2 and 4 are aggravated child abuse. So I covered here. I've seen a lot of questions about that. Let me pull up the information and we'll just read them. So these are going to be a little more factual specific. All of these counts, there are 3 counts per victim. All of these counts cover different subsections of the aggravated child abuse statute. So it's 3 different subsections. Some of these, and I have not pulled the case law on them, but some of them may be lesser included crimes of the other ones. And what that means is if it's a lesser included, the lesser included cannot be sentenced consecutive to the other cases. The lesser included means it's included in one of the other counts. And because I would not be surprised if per the sentencing matrix, counts 2 and counts 5 are lesser includeds, and that is, or counts 2 and 4 are lesser includeds of the other counts, meaning you can't sentence them consecutively because they're included. It's like in the Duggar case, you saw that there were multiple counts. He was convicted by jury of multiple counts, but at the end, the second count or the third count or whichever one it was dismissed because it was a lesser included of the other counts. So it just might be a function of law that you can't be sentenced to all of them. So it makes sense to dismiss them. But the counts that were dismissed are those starvation counts or the withholding food counts. But those are also seemingly included in counts 1 and 3. So the behavior is accounted for, but the counts are dismissed part of the plea agreement. So with all of that, Miguelina, I see everybody's asking about a press conference with Jodi's lawyer. We can take a look at that if we want to. If you will grab it, we can. So, question, what would happen if they did not agree to go to prison? The state would go to trial. So I'm going to answer a few of the questions that we've got as we go along, because you guys have a lot of great questions. So Buttercup earlier had asked why the second degree charges. It is part of the statute. Eric, thank you so much for the gifted memberships. It's incredibly generous. Law nerds, you guys, it's raining gifted memberships today. So B2 and Eric and everyone else who has gifted memberships are absolutely holding it down. So thank you so much, Eric, for all of those gifted memberships. It's truly, truly generous and incredible. Thank you. Catherine Fraser said best scenario for the children, but accomplices. I'm not quite sure what the question is, Catherine. I apologize. I think this is absolutely the best case scenario for the children, and these women will go to prison on a first offense. And I think that is an important thing. They will be punished for this, and the children will not have to testify. And then the family law court, I mean, as to Jodi doesn't need to have anything done to be kept away from these children for like indefinitely. But with Ruby, they can move to terminate parental rights if they want to, not just put custody with somebody else, but terminate parental rights. Will they do that? I don't know, but we will see. Josephina, will Hildebrandt get more time since she's a professional? I don't think that will factor in. It's not one of the sentencing factors. If anything, they're going to take a look at Ruby Franke being the parent here, and not Jodi Hildebrandt. I just wonder if they will get the same amount of time. They are charged with the exact same things. So I wouldn't be surprised if they got the same sentence. Do you think they both plan to plead guilty, or do you think Ruby's plea scared Jodi? I've seen a lot of conversation in the chat about what was said in the press conference. I think that once all the discovery was turned over, these defense attorneys had very real conversations with their clients that there is not much they can do in with these cases. There's really not much that can happen. The 911 call alone and the police showing up and taking in one of the victims and the condition the victims were found in is going to be enough that this was not going to be a difficult prosecution to go to trial on. It is then the job of the prosecutor to not go, hey, this is a trial I can win, but say, hey, what's in the best interest of justice and these victims who are children? And I think these women agreeing to go to prison and to not put these children through trial is a benefit, a huge benefit. I'm not sure if asked or if in the docket, but will there be a year-end review update of the cases covered in 2023 and a look forward into 2024? Joe, I am going to do a New Year's roundup for the members. So there will be a members episode covering all of that. Could the fact that she lost her license before be taken into consideration? if she lost her license for complaints like this, it could be a pattern of behavior, and it will be mentioned in the pre-sentencing investigation. So we talked about the plea. Could Jodi be charged with her other horrific offenses in relation to her niece who has publicly spoken? Cornish, it depends on when those things happen, if the prosecution knew about them. If the prosecution knew about them when these pleas were taken, then no, because you can't just hold on to charges and then spring them on a defendant after they plea. It also depends when it happened, and when it happened, and the statute of limitations in that will largely dictate whether that will go forward. So if we're talking 15 years ago, that's going to be very difficult. If we're talking 2 years ago, you would have expected to have seen those charges added when these charges were done, because the prosecution needs to charge everything that they are aware of before they dispose of a case. So I would be surprised if we saw any more charges for either of these women at this point, unless behavior has happened afterwards. But there's no indication of that. They've been in custody. Question, are Jodi and Ruby kept apart in jail? Yes, they cannot have any contact with each other. I thought Ruby was testifying. Nikki, Ruby would only need to testify against Jodi if Jodi went to trial. Jodi did not go to trial. When will the plea agreement docs be released? Now. Question, do you expect Jodi's sentence to be similar to Ruby? I imagine they will be similar. So will they be tried on the counts they are not pleading to? Mari, HK, no. The counts they are not pleading to are dismissed by the prosecution per the plea agreement. There was a lot of confusion about this. Dismissed by the prosecution doesn't mean they can't prove them. It just means that this is part of the plea agreement. It can be a function of law that those are lesser included. It can just be a, we get to the plea we need to get to with the most serious crimes, and we dismiss the other two as part of the plea agreement. If you're agreeing to the PSI, the prison, the consecutive sentencing, and all the rest of it. So, let's see. One sentence could they be housed together? They could be. It just depends. It really depends if there's other issues of safety and consideration, and the Department of Corrections will determine that. Was this the same judge that did Ruby's hearing? Yes. Will it be a different judge at sentencing? No, unless something happens to this judge. Who decides the amount of the sentence? Another Law and Crime channel said it would be a different board panel. Can't remember the name. Beachy, you're asking about the pre-sentencing investigation. In the pre-sentencing investigation, the Department of Corrections, the prison system, will look at the defendants and do their report. They will look at what the charges are, what the evidence is, what the underlying facts are, any impact statements. They will talk to the defendants. They will talk to family members. They will do a full workup of the case, and that workup will go to the judge. And ultimately, the judge will either agree or not agree with that. Debbie in the chat asked, will there be parole after prison? I don't know what percentage these cases are, so it depends. It's possible. Thank you, Miguelina. So it's possible. Let's see. Will there be parole after prison? It really, really depends on how long they get sentenced, but there's nothing in these pleas to keep them from being eligible for parole. Do victims get a chance if someone can't get a choice if someone can take a plea? It really, Tusrat, it really, really depends on the circumstances. The victims are told if there's going to be a plea. They are advised of what the plea will be. Victims can object to a plea and not agree with it, and the judge can still take the plea. There are times that cases will plea over the victim's objection. I doubt that's what happened in this case, but do victims get a choice? They get informed. They are taken into consideration, but are they the last determining factor? No, they are not. Because the overall system, the prosecution doesn't represent the victims. The prosecution represents the people of the jurisdiction that they represent. So for, federal prosecutors, AUSAs, it is the people of the United States. For county prosecutors, it is the people of the county of wherever they represent. So their job is to make sure that justice is done for those committing offenses in their jurisdiction, and also to make sure that what is done to the victims is punished, but they are not the representatives of the victims, if that makes sense. Will they have to register as sexual offenders? No, Rachie, there's no charges that would warrant that. Could they have to register as violent offenders? I would have to check the statutes in Utah, but no, not under that type of registry. Why do plea deals exist? Plea deals are a very large part of the criminal justice system in the US, because otherwise the system would screech to a halt. There is not enough attorneys or courtrooms to take every single case to trial. It also allows people to not have to wait the 2 years it can take for a thing to go to trial, and move forward in the process. It also allows people a benefit of accepting responsibility early, and it allows the system to not come to a screeching halt. Shauna said, will there be victim impact statements? It depends. Or will they be allowed to speak at sentencing? Also depends. With victims this young, it's also possible that there will be a representative of the victims from the victim assistance program who can read statements if that's appropriate, or other family members that read statements. So it really truly depends, but all of those things are a possibility. So it is a possibility. If they're paroled, can there be restrictions? Yes, parole can do just about anything. How much, if on the scale 1 cup of mega pint of coffee, did that cameraman have? Multiple cups of coffee. Multiple cups of coffee. Would Jodi's niece Jessie be a part of Jodi's PSI? I don't know if they will reach out to all of Jodi's extended family. They can. And if Jessie has participated in any of the investigation or spoken with law enforcement, then they will have that contact information if they need to. I wonder if Daryl Burks was offered a plea deal. Vanessa, very different circumstances given the amount of people that were killed in the first in the parade case. I think it was unlikely, and they said go to trial, do not pass go. Plea deals aren't always offered in homicide cases. In most other cases, you can generally work out some type of plea. So Michelle said the attorneys had a news conference after the hearing. We will take a look and see if we find a good video of that. River said, hi, my brain is mush, so just imagine I asked something really smart here. River, brilliant. Thank you for that insight. I appreciate you. Frank said, we appreciate you. Thank you. We had a good Christmas. I'm going to try to get to questions, and then we'll just get to chit-chatting. I was wondering about that. Thanks for explaining the lesser included charges. I would need to do some research. Again, my jurisdiction was California, but it is not unusual that a statute will cover like option A, option B, option C, option D, and some of those are included within the other. Those become quirks of sentencing. There might just be no point of doing all of the charges practically. There also might be legal quirks as to why, but it's not practically something that matters. Dismissing 2 counts when they are pleading to 4 counts of aggravated child abuse, the sentence is going to be the same. So why did Jodi's attorney say they didn't agree with some of the facts? Probably because they don't agree with some of the facts in the factual basis, and wanted to make it clear on the record that there is some disagreement. I'm sure they talked to the prosecution about it and are just making a record for down the road that there were some of those facts that they didn't exactly agree with. So that is why. Doing their job, protecting their clients' rights. Diego said, do you think once this case is fully done, the state can look into Kevin? I imagine that happened as part of this investigation. There's been a lot of time since this arrest. I did a whole episode of my podcast about whether I thought Kevin would be charged, and my thoughts on that have not changed. I don't think, based on the time frame of these charges, that there's any evidence that Kevin was living in the home. Do I think that is when you have charges that take into consideration allowing someone else to do these things, Do I think that's an easy out? No. I think Utah wrote their laws in a way that he could have been, if they could have proven that he knew what Ruby, Franke, and Jodi were doing to the children. I don't know if they could prove that it was known during that time, because it was known that he was living apart from them. They also weren't reaching back in time. These were in a very limited window of time. Let me pull that up really quick. The window of time that they were looking at for these charges was May 22nd to August 30th, 2023. So it really is a narrow window of time. And if it can be shown that Kevin wasn't living with them and didn't have contact with the children and didn't know what was happening, then he's not going to be charged for what happened during this period of time, which I break down in another episode. I hope that helps. Carbonized Stardust said it's still excuses. You say he hasn't had contact for over a year. Why? I agree with you. I don't disagree. I don't disagree with you at all. It's odd that he didn't have contact with his children for a year, but a prosecutor can't sit there and prove that he knew what was going on and was allowing this to happen if the children were living with their mother. So this is a morality legality divergence, because the morality side of it is very much, why aren't you checking on how your kids are doing while they're with their mother? But the legality side of it is, how do you prove that he was allowing this to happen when he was estranged from his kids? So it becomes a very difficult thing to prove, the morality versus legality. So, do I think Kevin will show up for sentencing? It depends on what is going on in the custody side of the case. So, it really depends on what was going on in the custody side of the case. Let's see. I'm just trying to pull questions. The chat's busy. There's over 11,000 of you here, so thank you for your patience as I pull them up. How will Ruby and Jodi be treated in prison given the nature of their convictions? I am not going to comment on that. I am sure prison will be a different experience from what they are used to in their life. Unrelated, law related, what's your experience with attorneys and face piercing tattoos? First year college student interested in law with a lot of piercings I'd be sad to take out. Zachary, don't let anything quell your interest in law. There is always room for you to find an area of law. And I think the type of law you practice definitely has some difference. I've also seen lots of attorneys and judges with nose piercings, eyebrow piercings, lots and lots of ear piercings. Times continue to change. The rules of what is a problem versus not a problem is different. And it also depends on where you practice. If you're in-house counsel for a really stuffy bank, there might be a little bit more of an uphill battle there. If you are in-house counsel for a record label, there would be a lot less of an uphill battle there. So it really depends on what you practice. Don't let anything quell your interest in law. If you want to do it, do it. B2, that's incredibly generous. Thank you. Thank you very much. We are looking forward to a very happy new year and probably some whiskey. It's probably going to happen, B2. Thank you so much. It's always good to see you in the chat and everywhere else. So yes, if you're interested in law, go do the law things. And find a field that fits you. You probably wouldn't want to work for a super stuffy bank that's going to be like, oh, I don't understand these kids these days. Also, there are so many law jobs that are remote that are not in-court law jobs. Like the in-court law jobs are such a limited scope of law. It's what we all see, but it is a very, very narrow part of law. Law is big and vast and wide. And if you work in the field of tech startups, you're going to look, the thing I learned the most when I went to the YouTube headquarters in LA is that coming to work in really comfortable pants and Ugg boots is totally cool. So if you're working for like an indie tech startup or a gaming company, they're not going to give any shits, and it will probably make you a cooler lawyer. So lawyers have legal experience. Find an area that interests you. The area of law where you have to be in court is a very niche and small area of law. The law is vast. It's so vast. And there is so much that is needed. So find your jam and it will be fine. Do not worry. Executive Goth said he proposed. Big fans here. Shout out to Alex finally asking me. We bum your commentary when working from home. I love it. He's watching now, so a shout out would be a cherry on top. Well, Executive Goth and Alex, congratulations on your engagement and pending nuptials. Happy all the things, and yay, cherry on top. We're going to continue to answer questions if I could grab them. Let's see. Thank you. You are welcome. Laura said, I saw an attorney in Utah say in Utah, the judge does not decide the sentence. They said the parole board makes the decision. I will take a look. Again, Utah is not my jurisdiction. They're normally pre-sentencing, and this has been my experience. I am not a Utah attorney. Pre-sentencing investigations normally have a recommendation, and the judge is the one that determines the final sentence and whether that's appropriate or not. But we will see. We will see what happens. In court, it's very possible, but generally the court goes along with the recommendation in the pre-sentencing report either way, but the judge ultimately decides whether they're going to go along with it. I don't think it would be odd to me if there was a quirk of law that says the judge doesn't get to decide, they just have to rubber stamp whatever the Department of Corrections said. That would be odd. But does the judge normally go along with what those reports say? Yes, generally, particularly when it comes to juvenile court. RK said, so lesser included is like ordering a supreme pizza. It includes pepperoni. You don't get a side of pepperoni. Yes, it's included. It's included. How weird is it that there's this much court activity in December? It feels like people want to wrap up their cases and get them off of their docket. That's how it feels to me. When is your in review on? I haven't decided yet. I need to sit down and put it together and record it. And I've been happily watching my kid play Mortal Kombat on the PlayStation while I've been checking in with my villagers in Animal Crossing who are like, when you left 10 months ago, I thought you would be back. Like, my villagers are so angry with me. Like, so angry with me. Sarah Smith said, considering law school, but unsure as a new mom. I completely understand that. There are lots of programs to look into. There is part-time law school. There is nighttime law school. I know plenty of people who went to law school with young kids. Do I think that's an easy thing to do? No. Are there options? Yes. Don't make any big decisions right now. It depends on how new as a mom you are. Give it a minute. And know that that's always available to you. So give it a minute. It's not easy, but there's lots of options. Thank you guys for all of your memberships. So parole decides, judges can recommend. I need to look at Utah. That is an odd thing because generally the judges are the ones who are given the authority to ultimately make those decisions and agree or disagree. I did not remember it was Fill Your Kindle Day. So all of the Kindlers, fill your Kindle. Carbonized Stardust says, hello. How is the husband not being charged as an accomplice as he left the children with Ruby and knew what she was up to? I don't know how they prove that he knew what she was up to. I just don't know. I don't know how they would prove that. So I don't know how they would prove that. That's where I'm at. Ashley D said, wishing all the law nerds a safe and happy new year. Can't wait to see what fuckery 2024 brings. I mean, it should bring a trial in Idaho is what 2024 should bring. You know what? I want to put up a poll, but I don't know if the poll is working. But I want to see if we need to review, the hearing again, because it was so quick. Jodi gets to plea. Look. Oh my God, my husband's scared. I was like, what is in my yard? My husband filling the bird feeder. Yes, Jodi gets to plea. I know sometimes it feels like they should be made to go through trial and made to sit and confront everything that they've done, made to hear all of their acts, made to be confronted by those that they harmed. But in a case where we are dealing with absolutely horrific abuse of young children, I don't think that is the best for the children if the defendants are willing to plead to something that is reasonable. And when I say reasonable, if Jodi Hildebrandt had come into court with her defense attorney and said, we'll only take probation, the prosecution's going to be like, no, you're not going to get probation. Oh, we only want to do 365 days local custody. No, that's not within the realm of possibility. But when they're willing to say, I will plead to 4 counts, I will go to prison, I will do it consecutively, then you get into, okay, this we can work with, and the victims don't have to plea, or the victims don't have to testify against them because of the plea. And that is a good thing for the victims. And I think in a lot of these cases, particularly when we're dealing with child victims, the goal is to protect them as much as can be done after this has happened to them, so that they don't have to come to court. Court is a traumatic experience for witnesses and victims. It is not easy. Some feel vindicated after getting to sit and tell their story. Many don't. Many feel terrified and traumatized because they have to tell the most awful things that's ever happened to them in public, in front of a jury that's judging them, in front of a defense attorney that doesn't believe them and is cross-examining them and trying to make them seem like a liar, and in front sometimes of cameras and in front of an audience full of people. It is not an easy experience. So protecting the victims for that, I think, is appropriate and a valid goal here. So, Jessica asked, why is it even legal to bring children into the courtroom when they've often already given witness statements and such? They don't need to be re-victimized. Such an archaic method. Jessica, I can answer that question. It's because the Constitution has a right against, or a Sixth Amendment right of confrontation. So you cannot prosecute someone without bringing their accusers against them. And when the victims are children, the victims have to come into open court and testify if it goes to trial. So giving a statement giving a statement to law enforcement is not the same as giving a statement in trial in front of a jury subject to cross-examination. So the answer to that is because of the Constitution. So that is why. So Bean said, I expected Jodi to take it to trial. Same. I wonder how much Ruby's plea factored into that. Maybe it didn't. Maybe it was the evidence against them. I would imagine. No, wrong one. Damn it, Emily. Today's not the day. I would imagine that they did forensic interviews of the victims on video, and Jodi and Ruby would have had an opportunity to watch those interviews, and their lawyers would have had an opportunity to say, here's what's going to happen when a jury sees these victims testify. And this is what a jury is going to think and feel. And so even if you're trying to argue that it really wasn't as bad, there's no arguing that this really wasn't as bad. Here's the 911 tape with the neighbor crying, seeing the state of this victim who escaped your house and ran for help. So if you go in front of a jury, they are going to ask the state legislature why they can't punish you to more, because a jury's going to want to bury you underneath the courthouse after hearing what you did. So your best bet, if you would like to get out of prison at some point in the future, ever, is to take a plea deal. That is why. So I imagine that they were confronted with all of that and then moved forward. Crime and Crochet are my hyper focus. It's a great name. In the UK, children usually appear via video link, which is much less stressful for them. Different rules, completely different court system, different rules. So in the US, in criminal cases, it is very rare that anyone's allowed to testify via video link. I don't know if post-pandemic, those things will start to shift a little and they can still be subject to cross-examination. That's happening more in civil cases, but not as much in criminal cases. So What happens to all the evidence that would have been used in court? It stays sealed in police files until the case is all the way done. But it stays sealed. Some of this will not be subject to Freedom of Information Act requests, which I appreciate in cases like this. So let's see. Nikki says, love it here, Emily. Thank you so much for being my Pogo friend. I've been off for a couple days, but I will be back. I will be back to Pogo. Let's see. I want to make sure I didn't have any other questions I needed to swoop before we go to the hearing again and then the press conference. When a client pleads guilty, is that considered a loss for the attorney? Astra, I have not been a defense attorney. I am friends with a lot of defense attorneys. Generally not, because there is some benefit to the defendant. And if the defendant does not have to particularly pay to go through trial, if they have hired retained an attorney, and they get some benefit, meaning less time, take responsibility early, and are able to start to move on, then no, it's not a loss. I think for a lot of defense attorneys, a client who refuses to plea, who they think should plea, who's offered a plea deal by the prosecution for, and this is just a hypothetical, for 10 years, and they're offered a 10-year plea deal, and they're like, no, we're going to trial. No, we're going to trial. And then they go to trial, and then after trial, they get 35 years. I think that probably frustrates the attorneys, where they're like, I kind of advised you that this was going to happen. I think that can be very frustrating. But when somebody gets a good plea deal, I don't think that is a loss at all. I think that's doing a good job for your client. So let's see. All right, we are going to, I didn't get to all, Troublemaker Baker. I see the cookies. They look delicious. Jodi's lawyer claims she made the choice to plea before Ruby. Let's go to that hearing, shall we? I'm sure you guys are going to have more questions. I will pull them up as we go. But let's go to this court hearing, and then let's go to that press conference. So let's do 2 more hearings. We're going to review this hearing real quick. So we have kind of a cleaner review of it. I will be flagging your questions as we go through it. And then we'll do the press conference. So for those of you just coming in, you didn't miss anything. We're going to go over the plea hearing, and then we're going to go to the press conference. Let's go. Jodi Hildebrandt pleading guilty in 3, 2. Emily, move yourself.
Versus Jodi Hildebrandt, case 231501763. Mr. Clark and Mr. Sham are here representing the state of Utah, and Mr. Terry is here with Ms. Hildebrandt. We are scheduled for a waiver of preliminary hearing. Mr. Terry, it appears you have just handed the court a signed plea agreement.
That is correct, Your Honor. With respect to the waiver, Ms. Hildebrandt, we have had discussions. She fully understands the purpose of a preliminary hearing, what the burden of proof would be, and she has the right to a preliminary hearing, but in conjunction with the entry of her plea today, we waive the preliminary hearing.
And in fact, there is a provision in the written plea agreement that operates as a waiver of the preliminary hearing. All right. Ms. Hildebrandt, I've been handed a written document, a plea agreement with your signature on it. Did you sign that document?
Yes.
And you did that to represent to the court that you have read the document carefully, that you understand what you've read, that you agree to all of the terms that are set forth in that written document?
Yes, sir.
You've had sufficient time to ask Mr. Terry any questions that you have about the agreement or its potential effect?
Yes.
Is anyone pressuring you to enter into this agreement, or is anyone promising you anything that I haven't been told about or that is not in the written document?
No.
Are you under the influence of alcohol or drugs today?
Standard plea provisions.
Is there anything today that could interfere in any way with your ability to understand the agreement, its potential consequences?
No.
No physical condition, mental health, or emotional condition, nothing that could interfere with your present ability to evaluate the agreement and decide if it's what you're prepared to do today?
No.
You don't need more time, you're ready to go.
Yes.
Any further record, counsel?
Your Honor, the agreement contains a factual basis. There are a few details in the factual basis that we are not in full agreement with. However, this is a guilty plea. It is not an Alford plea. The factual basis sets forth facts that we agree with, that Ms. Hildebrandt agrees with, that are sufficient for the court to accept her plea with respect to the 4 counts to which she is pleading guilty. And so we ask the court to accept her plea agreement.
The defense isn't really in much of a position to pish-posh with the prosecution over the details of that factual basis. They really don't have any room to say, can we just change these few details? The prosecution's like, this is the factual basis for both defendants. That is it. We're not changing it, plea or don't. So here we go.
And apart from what is in the written factual base in the plea agreement, you have, I'm assuming, reviewed voluminous discovery. You don't dispute whether there is an actual or an adequate factual basis.
We do not.
All right, then. Anything else before the court receives Ms. Hildebrandt's pleas?
No, Your Honor.
Nothing for the state, Your Honor.
Then, Ms. Hildebrandt, how do you plead to count 1, aggravated child abuse, a second-degree felony?
Guilty.
And to count 3, aggravated child abuse, a second-degree felony?
Guilty.
To count 5, aggravated child abuse, a second-degree felony?
Guilty.
And to count 6, also aggravated child abuse, a second-degree felony?
Guilty.
The court finds that there is a sufficient factual basis. The court, in addition, finds that Ms. Hildebrandt's pleas are made knowingly and voluntarily. The court, therefore, accepts and enters those pleas, dismisses the remaining 2 counts. We are anticipating a PSI, although part of the plea agreement appears to be that Ms. Hildebrandt will not contest a prison sentence.
Correct.
Is that right?
That is correct. But we are asking for a PSI.
All right, then the court orders the preparation of a pre-sentence investigation report and sets sentencing at 10:30 a.m. on February 20th. Anything else for today, counsel?
Nothing from us, Your Honor.
Nothing from us, Your Honor.
All right. Thank you. We'll be in recess.
And that's it. That is the entire plea. For those of you coming in, we have covered this once. I'm going to zoom through a few questions. The PSI is the pre-sentencing investigation, sometimes also called a PSR, pre-sentencing report. The Department of Corrections does a ton of interviews. They have a whole process they go through to evaluate what an appropriate sentence is, looking at the case, looking at the defendant, looking at the defendant's background, looking at statements the defendant made, statements family members have made, and the rest of it. So they go through and recommend a particular prison sentence to the court. So that, well, sometimes I recommend a probationary sentence, but in this case, they've agreed to a prison sentence. So that is what's happening in this case. So that is what the PSI is. The court will review that. So how long do PSRs take in the US? This is pretty fast. In the federal system, it's months. So the fact that they're sentencing in February is pretty quick. 90 days is generally the minimum. So with that, we are going to go to the press conference and then answer more questions. So let's go there to cover the press conference given by the defense attorney. And see what we got. Let me cue this up. Oh, that's cute. It's queued right up. Hopefully the sound isn't shit. These press conferences outside of courthouses aren't always easy.
Much to say about this case prior to today because I didn't feel it was appropriate.
You've said nothing about this case. So yes, that is an understatement. But I appreciate the defense attorney being like, going to the media is not my first consideration in this case. Like we just need to do our work.
I haven't had much to say about this case prior to today because I didn't feel it was appropriate to do so until today.
I appreciate that.
Ms. Hildebrandt, my client, has pled guilty today to 4 counts. She has done so because she takes responsibility for her conduct in this matter. Her guilty pleas she decided to plead guilty before Ms. Franke entered into her plea agreement or agreed to cooperate with the state. She has pled guilty because she wants.
I'm going to go look at the date that's signed. She might have said from the beginning, I just want to plea. That's possible. We're never going to really know. But we might, you know, suppose one way or the other. But Jodi might have said at the beginning, yeah, we're just going to take a plea. We don't know. But this is her statement. I mean, the other lawyer's statement threw Jodi under the bus, so her lawyer might be doing a little bit of cleanup.
She did not want these children to have to testify. She
So
takes
there's that.
responsibility. And it is her.
Hey, counsel, someone should have maybe had a conversation with her about not abusing children before we got here. I'm just saying.
Her main concern at this point that these children can heal both physically and emotionally.
Now she's concerned. Now I'm sorry. I really do want to get through this hearing, but her only thoughts are the children. Sir, you know what the facts of this case look like. So now her concern. Now her only concern are the children. No. Yeah, no.
She has pled guilty because she did not want these children to have to testify.
Doing his job.
Takes responsibility.
He's doing his job.
And it is her main concern at this point that these children can heal both physically and emotionally. We look forward to sentencing. That's all I have to say today.
We do too. How long is your client going to prison for?
There are people all over the world that are coming out and saying that Jodi Hildebrandt has destroyed families, that she has hurt a lot of people. Has she seen this kind of the backlash that's happening? And what?
Ooh, I don't know which media outlet this reporter's with because they didn't say their name or outlet, but this is a great question. Hey, this is not just about these kids. What about all the other families your client's destroyed? 10 out of 10 question.
What does she have to say about it?
I'm not going to have any more comment, nor is she, at least prior to sentencing. Thank you.
When will the sentencing take place?
February 20th.
Thank you.
In terms of the agreement, as far as how that pertains to sentencing, and is there a specific range that the court has agreed to?
No.
She's agreed to a prison sentence.
No
4
range.
counts, consecutive, the same as Ms. Franke. Exactly the same as Ms. Franke.
In Utah, there's rumors about consecutive sentences. How long could her sentence term be then? Could all 4 be consecutive together?
Yes.
Ultimately, it's
All 4, ma'am, all 4 consecutive together. That could be 1 year. That could be 2 years. That could be 3 years. That could up to 15. I'm going to let him answer though.
up to the Utah Board of Pardons. And I'm not going to.
The Utah Board of Pardons, different than Department of Corrections, different name. So that is who is determining. He says it's up to the Utah Board of Pardons who's doing the PSI.
Speculate at this point how long she might serve. Thank you.
Fair. All right, let's see who's up next.
I'm Washington County Attorney Eric Clark, and I
Thank you for introducing yourself, Eric Clark.
just have a brief statement that we'll read, and then we'll be happy to release this along with the signed plea agreement to anybody
Eric, sunglasses, my guy.
who requested today. So this morning, Jodi Hildebrandt pleaded guilty to 4 counts of aggravated child abuse. She will remain incarcerated, awaiting sentencing, which will occur on February 20th, 2024.
We know this.
As part of the plea agreement, Ms. Hildebrandt agreed to be sentenced to consecutive as opposed to concurrent prison terms for each.
We all appreciated that. We could have just watched the press conference, but we went seeking out the information in the court documents as we do. It's a very big deal, the difference between consecutive versus concurrent. So it is why I'm like, this is a big deal.
Each of the 4 counts. One of the toughest things we ask victims of alleged abuse to do is testify in a trial against their abusers. We are pleased that in this case and in Ms. Franke's case, that won't be necessary. That both defendants will be going to prison without having to hold a trial.
Yep.
We're grateful to the multidisciplinary team that investigated this case. we have great law enforcement officers, caseworkers, children's justice center staff, both in our area and in Utah County. Additional information about Ms. Hildebrandt and Ms. Franke's cases, including redacted investigative materials, will be available upon request 30 days after sentencing of both defendants. For further information, please refer to the statement of defendant in support of guilty plea that was filed with the court this morning, and we'll be happy to make that available.
It's available
Guys.
Why were 2 of the counts dismissed?
because it's a plea agreement.
So in any plea agreement, there's always some back and forth in that. And in this instance, 2 counts were dismissed. And what Ms. Hildebrandt agreed to do was to not contest that for each of the terms that we prison, and that those were consecutive as opposed to concurrent.
But why not all 6?
Well, so I think that's a fair question. And that's what, as a prosecutor, that's what you deal with every time you're handling a case, right? Is
Why not all? Because we don't want to go to trial.
if our plea offer had been there is no plea offer, plead straight up to all 6, then the defendant has no
Incentive at all. Yep.
And we're not afraid of trials. We don't want to avoid trials. Trials carry some risk in that you don't know what the outcome's going to be, but more so when you have victims that are having to go through the trial process, that's difficult.
Yep.
And so if we can get a result that is similar, in Utah, there's the maximum penalty.
Okay, he's good. I hate that a truck is going by, but he's going to explain the Utah maximum penalty, which I see you guys discussing in the chat. So the prosecutor is going to explain what is happening. So, that's what we're doing. Wait, I wasn't expecting these penetrating questions. They're really like, but why are you dropping counts? And he's like, that's how this works. But I'm interested to see what he's going to say. And most courthouse interviews, because most courthouses you cannot film within the courthouse, are right up on the street. So they are doing these on the sidewalk right at the street where cars are going by.
In Utah, there's the maximum penalty for second-degree felonies is 30 years. So if we had 15 counts, the maximum amount of time would have been 30 years. And each count carries a 1 to 15 years. So the difference in reality between 4 counts and 6 counts, in our calculation, wasn't enough to justify asking victims to go through a trial.
He's like, right, it doesn't matter. The max we can get is 30, so it doesn't even matter. So what he's saying is for second degree, and a lot of you have asked what the difference between second degree and first degree is, and I've said repeatedly it depends on jurisdiction. He's like, look, in Utah, these are second degree. We can never get more than 30 years, so it doesn't matter. As long as we had 2 counts consecutive, if they maxed out, then they maxed out. So that is part of their discussion here, and that's what they're talking about. I know that they've been talking about that in the chat. Look, the ins and outs of sentencing in particular jurisdictions are very, very determinative by the jurisdiction. So in different jurisdictions, there is not a cap on what your maximum is based on how many charges you have if you have different victims. So in some jurisdictions, there's a cap on how much time you can get if it is one victim with multiple acts. But then when you get to multiple victims, the time goes up. So it can be different. So your states are going to be different and your counties can be different.
Part of Ruby Franke's plea deal was to testify against Jodi Hildebrandt. That was like a big part of that plea deal. Does that mean that is irrelevant now? She will not have to testify against Jodi?
Ma'am, Jodi pled. There's no need for Ruby to testify because Jodi pled.
That's what I anticipate.
When
It is
comes
moot.
to, prosecutors always have to determine who they think is the more culpable party in co-defendants. Who do you believe is the more culpable party?
Ooh.
I'll be more comfortable speaking about specifics in the case
After sentencing.
After sentencing, and then we wait for the 30 days to make sure that appellate time is run. And that's just us being super careful to make sure that procedurally.
That is a smart answer, sir.
And overturn a conviction. So I'm not going to get into thought processes at this point.
Smart.
KSL 5 News, the defense attorney.
He's like, y'all are going to forget about me 30 days after sentencing, so come back then and ask that question.
That Hildebrandt.
And Belle, now I'm hidden. I have not seen many jurisdictions have life as an option on second degree crimes. Does it mean it can't happen? It can, but I have not seen life as an option on second degree in my memory.
Chose to plead guilty before Ruby Franke made the decision to plead guilty. Is your office aware of the timeline there in which Plea?
She's asking the prosecutor, and it's very low, but she's asking the prosecutor, did Ruby really agree, or did Jodi really agree before Ruby did?
Which agreement happened first?
No,
Ma'am, it's irrelevant. They both pled.
in that we weren't talking to both Hildebrandt and Franke, right? It was clear to us we knew that Franke was going to plead earlier than Hildebrandt. Thus, like Franke's the deal that Franke pled to included her agreeing to testify against Ms. Hildebrandt, and also that we would not submit things to the parole board asking that she stay in prison for a longer term. So that was in Franke's plea. That's not in the paperwork that you guys will see for Hildebrandt's plea.
So the reporter said, look, defense attorney for Jodi Hildebrandt said, we agreed, we decided to plea first. And in this case, you're seeing him say, we knew Jodi was going to plea. We didn't know Jodi was going to plea. We knew Ruby was going to plea first. So we put things in Ruby's plea because we knew Ruby was going to plea first. It doesn't mean that Jodi and her attorney might not have communicated that they're willing to take a plea deal and then have it communicated to the attorney after. But the attorney said, we knew Jodi was going to plea before Ruby, or we knew Ruby was going to plea before Jodi. Apologies. It doesn't mean she didn't communicate early on to her defense attorney that she was going to plea. But as far as the prosecutor's knowledge, they locked in Ruby's plea first. And I'm not surprised. And then they would have called up the attorney for Jodi and been like, what do you want to do? So I thought that was playing. Go ahead.
In Franke's case, you agreed to stay neutral for parole board hearings. Did the same agreement happen with Hildebrandt or no?
No, it's not in there.
And I know we can't predict the future, but so the door is open for the Washington County Attorney's Office to go to Hildebrandt's parole hearings and say, we believe she needs to stay in.
I mean, it's not in the plea
That's
deal.
a good question. So the answer to that is yes. More commonly, the prosecutor's office can submit a letter or submit things in addition to the pre-sentence investigation of my regulation parole. But there's always the option of actually going in person and being in those hearings also.
Depending on which office you work for, that's an option.
Aggravated child abuse in Utah is a second-degree felony. Do we need to look at these laws in Utah?
I hope so. And that's something that I've been in talks with legislators already about.
Thank you.
Is that as a result of
That is a very good question. Aggravated child abuse in Utah is a second-degree felony. Is that something we need to look at? And he's like, yes, this is something we need to look at, because were it not, then you could have potentially more time.
this case?
Like I said, I don't want to get into my thought process on this case until we're further along. But I have been talking to some of our legislators.
That was loud.
I have been talking to some,
The prosecutor is just like, go ahead and rev your engine. Go ahead. You see that there's an entire film crew out here. You've got a whole podium and a ton of reporters, but go ahead.
some of our legislators that are open to criminal justice reforms about the level of severity in Utah law.
When did those conversations start?
In the last few months. Thanks, you guys.
As far as child abuse cases, where does this one rank in your career?
Where does this case rank in your career? He's like, ma'am? it's a Tuesday. The only reason the media cares about this case is because she was on YouTube. This is not, sadly, an uncommon case. But I'm interested to hear his response. But it's like, where does this rank in your career? It's like, I still have a desk full of work to do, and it's the holidays.
Where does this one rank in your career?
It's just strange.
I'm not going to get into, again, I'm not going to get into my personal thoughts on this until we know that everything is done.
Good.
Thanks, you guys. Have a great rest of your holiday.
Thank you.
Thank you.
Yeah, he's not going to tell you this is the most horrific case he's seen in his career, because it's probably not, sadly. But I guess if they follow up, maybe the prosecutor will have more to say 30 days after sentencing. But it's where does this rank? It's like, I don't, go ask Creighton Waters. He seems to want to have a chat about Murdaugh. There are other prosecutors to ask about this. This prosecutor is like, and what do you want? It's a really sad case. So we're going to get, now that we've done the press conference, we'll get into a few more questions, and then we're going to wrap this up and let the amazing Mod Squad get back to their holidays and let y'all get back to your holidays. So I know, no, it's a Wednesday for us. It's just, I always default to, it's a Tuesday. I don't know. What day is it? It is whatever it is. So let us continue on. It's like, ma'am. Teresa asked, how will they be, or Teresa, sorry, how will they be housed? Will they be in the same jail? When these women go to prison, it will be up to the prison system to decide where they will be housed. Could they be together? Yes. Could they be separate? Yes. Could they be in different states? Yes. It's just all of those housing determinations will be based on space and what their needs are, but they won't be co-defendants anymore, so they won't have any requirement to stay apart unless there is other types of concerns that are needed. If Ruby is released before her children are 18, will she have a chance at regaining custody? Shauna, it really depends on what they do. If they terminate parental rights, then no. If they don't terminate parental rights, then there's always a possibility. But it's I would hope not, but we will see what happens in the family law side of the case. If her parental rights are terminated, then no. So that would be something to look for if it's reported on down the road. Did he say he would not submit certain things to the parole board? Rhonda, he did. That was part of Ruby's plea, is that if here, we've got, this question came up more than once. So Christina also asked, Ruby's plea deal included the prosecution staying neutral in sentencing. No, in the parole board. Did Jodi's plea include the same neutrality? So it was the parole board. So both of those questions are asking the same thing. And that was an agreement that if Ruby testified truthfully against Jodi, that the prosecution would then not go to the parole board if she was eligible for parole and argue for her to stay in custody. So that was contingent on, if you do this, testify truthfully, then we'll do this, not say anything. That's all kind of moot now because Ruby's not going to have to testify against Jodi because everybody pled guilty. So, SVDS said, sir, she is not allowed to talk about and for the children anymore. Yes, we don't want to hear but we were doing this for the benefit of the children. Stop it. Stop it. Stop it. Michelle said, can victim impact statements be read at sentencing? Absolutely can. There's a lot of different ways that can be done for children. If they have a guardian ad litem, that can be done. They can be done through victim impact. It can be done through older siblings if older siblings want to do that. But yes, victim impact statements can be read. They don't require the victims to be there in person. Laura, thank you for following up. Laura had asked about adequate factual basis, or about what the judge had said during the plea agreement, and I wasn't sure what was meant. So Laura, thank you for clarifying. The court said, is there an adequate factual basis for the plea? And the defense said, yes, there's an adequate, the facts alleged are facts that support the charges of aggravated child abuse. So yes, those facts that are pled in the factual basis are the crime of aggravated child abuse. So that's what that means. So hopefully that helps. What is the difference between first degree and second degree felonies? It varies by jurisdiction. What they mean by that, it generally is a denotation of severity of the crime. So there are different things that can attach, and what the prosecutor said is in Utah, that means that because it is second degree, the maximum potential sentence on second degree is going to be 30 years. So you max out at a certain amount. In first degrees, that's not going to be the case, but it tends to indicate severity, and that has different implications in different jurisdictions. Nick says, in your experience, what sentence would you expect them to be given? I have not worked in Utah, so I am not going to speculate. They are going to get at least 4 years in prison. So I would expect them to get more than that. Michelle, yes, I covered the details of Jodi's plea. It is essentially the same as Ruby's plea, except for the testifying against the co-defendant part of it. Executive Goff said Alex's whole ass fell out when you read his name out. Thank you. Alex, hold it together, man. Hold it together. Hold it together. Alan said, would the not agreeing with all the facts be a way of making any civil case less of a slam dunk? They pled guilty with a factual basis, so no. And those factual bases are written. So if there was any civil cases, which we don't know if there will be, but if there needed to be civil cases, these are guilty pleas, not Alfred pleas. So they're going to be, it's going to be done. Has there been any ruling on Jodi's license yet? I haven't been following along with that at all, so I have absolutely no idea. The chat might. Cyan said, if these awful crimes are second degree, what constitutes first? How do they define them at the time of charging? Prosecutors have to pick the crime that fits the facts. The determination of where different criminal behavior and criminal acts fall on that spectrum is up to the legislature. The legislature writes the laws, and then they get enacted, and then they see what's happening. And sometimes there's input from prosecutors and defense attorneys saying this isn't working and this is why, one way or the other. But what constitutes first degree is generally things like homicide, attempted homicide, cases that have, depending on the jurisdiction, like a great bodily injury allegation that can bump a crime different degrees based on the jurisdiction. So how did Utah decide that aggravated child abuse would be a second degree felony? I don't know. You know, what's interesting though, is if you were deeply, deeply curious about it, if you wanted to, you can go find these code sections. So in Utah, this is the Utah code, 76-5-109.2, different subsections. You can go and look at the legislative notes and history of a thing and see how they determined this and how they talked about this, and see how these decisions were made in the legislative history under the code. And you can generally find the Utah code annotated from the government website for the state and kind of go look through it if you're interested in it. Let's see. It's good to see you, Casey Cat. Thank you for being in the chat. Thank you so much. Ciao, Bella. In California, do counts equal strikes, or is it convictions equal strikes? Script Goddess, that is a much deeper conversation on the intricate functionings of California strike law. But generally with California strike law, it is the conviction. It has to be the conviction. But you could have a case where somebody is convicted of 5 strikes in one case under the strike law. But you can also have a case where somebody has previously been convicted of 2 strikes. And then depending on what the crime is, the 3rd strike can qualify you for life in prison if it's treated as a 3rd strike, but they can be treated as presumptive 2nd strikes. So there's a very long conversation about the intricacies of criminal sentencing for any jurisdiction, which is why I always say generally it varies by jurisdiction because it varies so much. And the intricacies of California strike laws are something that if attorneys don't understand, they can get their client in a lot of trouble. Criminal law is very, very nuanced and there's a lot to know. And so it's always interesting seeing attorneys that don't regularly practice criminal try to come in on criminal cases and just be like, well, what are we doing here? It's strange. So criminal law requires quite a lot of specific and intricate knowledge. Let's see. What do you think about the paralegal profession? I think that lawyers would collapse without paralegals, and paralegals generally don't get paid enough, and they get all of the shit and not a lot of the glory, but they do a ton of the work. This is Olivia has asked the very, very big questions in the chat today. What is the airspeed velocity of an unladen swallow? It depends if it is an African swallow or a European swallow. And it really just depends, like most things in law. Also, the airspeed velocity of an unladen swallow is up for much debate. Let's see. EDB, can Ruby have contact with Kevin and her kids? Not right now, she can't. Can they visit her and talk on the phone? After sentencing, it depends what the family law court does, and it depends if there are stay away orders from the victims. So we don't know yet. It depends. Let's see. If they go to prison here in Utah, it will be the point of the mountain. And chapstick drama, I appreciate that. It really, again, depends on jurisdiction. Some areas you will go to prison where you are convicted. Sometimes, depending on space, they will move you to different prisons. It really just depends. So, I saw this question from Ken. Who is the designer of your earrings? These are Kendra Scott earrings. So, are you suggesting that coconuts migrate? Perhaps. Just a little bit. Just a little bit. Jessica F says, as a paralegal, thank you for recognizing us. The legal world does not spin without paralegals. It just does not. But Jessica, you can also let the chat know, because I'm sure people in the chat will be asking about what you like about your profession. So, question. After a mother or father gets prison time for this, do they have to look at every family member? How the different agencies do investigations, because there are so many agencies involved in this particular case, will really, really depend. It will really depend on all of it, but that will normally be done earlier on in the investigation. And they had a multidisciplinary investigation here, which means they were working with law enforcement, child protective services, psychologists and therapists, forensic examiners, and things like that. So I'm sorry to have to say it depends, but it really, really does depend. Could Jesse and other victims give impact statements too? It depends. It really depends. So it's hard because they are not the victims of this case. It's going to depend what the court allows. But they are members who have been impacted by this behavior. So if they want to, I imagine that the prosecution wouldn't say no. But it's going to depend. So let's see. I'm going. Chibi said, but do we put a lime in the coconut? Yes, and drink them both together. Question from Bread and Tiger. After today's plea, do you think Jodi could be charged for the other kids she was counseling? We talked about that a bit earlier in the stream. If the prosecution is aware of other instances of behavior, they should have charged it before they discharged this plea. If those instances of behavior fall out of the statute of limitations, it's going to be much more difficult. Nina, I have an episode on the Emily show where I get into this, and I got into it a bit earlier in this stream. Could the children sue for IIED civilly once they reach the age of majority? I mean, they could sue through guardian ad litem now. They wouldn't need to wait. So it really depends. Could they civilly sue for harm done to them? Yes. Do they need to go through that? I don't know if they will need to, and I don't know if there would be any benefit there and if there would be any money there. I just don't know, because the civil recompense there is just money. I don't know how that will help. Let's see. Vanilla says, Emily, do judges know a lot of the background on these high profile cases? No. Or are they mostly oblivious to details before trial? Yes, Vanilla Rose, judges generally don't do like independent investigation of cases. They are presented the facts of the case by the attorneys presenting those cases to them. So the judge knows the facts of the case. Does the judge know that this person was a YouTuber? They might know because there's media requests, that there's media interest in this person. Would they ever have gone and looked for videos? No, they wouldn't. And it wouldn't be appropriate for them to do so. They rule on the facts before them in court. They are not dealing with stuff outside of court unless stuff outside of court falls into their lap. And we have seen that happen in high profile case after high profile case where there's been issues outside of court, like stuff said on social media or stuff said on Reddit that has come to the court's attention. Like these things are happening during this case, but they don't go looking for it. What, you guys have a lot of stuff in the chat. What in the world? Kevin Hart filed a lawsuit against Tasha K. What? Chat, what is happening? And did his lawyers call him Kevin Hart properly throughout the entire lawsuit? What? We can't derail. We can't derail. We can't derail. I'm putting it on the list for next year. I'm putting it on the list. I am putting it on the list for next year. For next year. Sassy Draco fell into our lap and we are here for it. Yes, but didn't fall into the court's lap. Kylie, this is a question I've been asked a lot. And I think it's a fair question. How is what Jodi and Ruby did to these children not attempted murder? Okay. Chat, stay with me here as we talk about legality and morality, and we're going to separate the two. We are going to have a strictly legal conversation here about the nuances of law, not about the feelings and morality, because how is abusing children not like horrific? So we're going to put aside the morality side of all of this is awful and talk about the legal side. When I went through the probable cause and the factual basis, a lot of what these women said that they were doing was punishment to modify behavior. And that the punishment to modify behavior was the goal, not to kill. So you're bumping into an intent issue with what the statements were that both the children gave and what law enforcement has written in their statements, that these things were not done to attempt to kill anyone. They were done in the most fucked up form of behavioral modification you can ever see. However, that means if you go to trial on an attempted murder, a jury's going to be left with facts of punishment that is horrific and very injuring and damaging, but not left with the intent to kill. And that is going to be the difference there. So it's going to be difficult to try to go down the road of, but shouldn't you know that this type of harm can lead to death? But that's different than like a first degree attempted murder, which is intending to kill someone and then them not dying. This is not that intent, if that makes sense. I understand that causing harm to someone, you're like, but I'm causing harm to them. Can't you see that harm could lead to death? But even when you're causing harm in a reckless way, and this is an aggravated child abuse, but when you're causing harm in a way that could lead to death, it's not the same as intending it to lead to death. So you've got some different things. And then you get into all of the nuances on the death statutes where you can have like attempted negligent homicide where what you're doing is really bad and it could cause death. and you should know it could cause death and you have to prove it. I wonder if the sentencing in Utah is higher on the aggravated child abuse than it would be on like a reckless attempted manslaughter or something. So then you would have to look at the statutes and take a look at what would constitute intentional versus not intentional. Because I imagine the sentencing for like a negligent manslaughter or an attempted negligent, if they even have, because not all jurisdictions do have like an attempted negligent homicide, because it becomes very far afield from the homicide statutes. But if Utah even has such a statute, it would get down into the it would get probably down into lower sentencing than 1 to 15 years. So with all of that, the intent is not there. And that's what the prosecutors are going to look at based on the statements of the victims. The victims were told that they were possessed, that they were being punished, that the punishments were necessary. And yes, the actions are horrible. And you would look at that and be like, but this can happen. But the intent is not there. So I don't know how you would prove intent when you look at the statements of the victims, how you would prove intent on a attempted homicide. So I know that that morally does not feel correct, but when you look at the written statute for an attempted homicide, I don't think you're going to get into that intent. So restricting airway, yeah, Kara, yes, because you can have restricting airway cases that are assaults and are not attempted murders, depending on what the circumstances are. So yes, you can. Yes, you can. So I think that these women were doing things that could kill these children? Yes. Do I think that that was their intent? Do I think they were trying to kill these children? No, I don't. I don't think they can prove it. I think it's horrific abuse, but I don't see how the prosecutors could, on the facts that we have publicly, how they could argue that. Though I do think that if the prosecutors thought they had those attempts, they would have charged it. But you can't overcharge cases because you will lose them at trial. You have to have a reasonable belief as an attorney, as a prosecutor, that you can charge this and prove it beyond a reasonable doubt. And based on everything that's public, that seems that they've picked the cases that they can prove. So the intent element is why, if that makes sense. I know it's not right. So it is what it is. So with all of that, Laura said intent is a hard thing to prove. Intent is a hard thing to prove, and especially when you have statements that go to an intent, definitely an intent to harm, but not an intent to kill. It becomes a very difficult case. So there's that. Let's see. I'm going to look at a few more questions and then we're going to wrap up. I know it's not a satisfactory explanation, and I get it. I get that the morality of that feels really wrong when you look at the legality of it, but intent is a huge part of proving these cases. We're getting into all the hypotheticals. Lisa asked, what about drunk driving cases? The drunk driver doesn't intend to kill, but it happens because they made a choice to drive and it ends with an accident with a fatality. Is that murder? Generally not first degree murder. There are, depending on the jurisdiction, there is case law that talks about the level of manslaughter. So in California, the Watson case makes those Watson murders where there is specific law that addresses that circumstance. But you also, for Watsons, have to prove that somebody knew that drunk driving could lead to death. So if you have a case, and I worked way too many Watson cases, but if you have a case where you can't prove that the drunk driver would have known that the case would lead to death, I had juvenile cases in juvenile court with like 14 and 15-year-olds driving drunk. And if they had killed someone, you can't necessarily prove they knew because they'd never been through driver's ed and they shouldn't be driving and they shouldn't be drinking. You can't prove that they knew that drinking and driving could lead to death. So you have to prove that there is a way to know. You have to prove in court that they knew that drinking and driving could lead to death and that they made those choices. So there is a whole separate and carved out side of law that addresses those circumstances, but not all drunk driving related accidents wherein someone is killed are charged as murder cases for that reason. So it is each jurisdiction has their own kind of carve out for drunk driving cases, but you still have to prove that they knew. And Dawn, a lot of them go the route of vehicular homicide, which is not the same as like a first degree murder, and also not the same as like an attempted murder. And if you drive drunk, like you look at like Shannon Bedore's DUI, really high BAC, collided with a building, could have killed somebody, but you don't charge it as an attempted murder because they drove drunk and could have killed someone, if that makes sense. So it is wild. Linda said, can Ruby appeal, saying that she was abnormally prosecuted specifically because of her social media presence? No, I don't think there's any room for Ruby Franke trying to appeal. And she could really only appeal her sentence because she chose to take a plea deal. Saying that she was prosecuted differently because of her social media presence. I imagine once we see her sentence, I imagine it will be in line with other cases of the same severity in the same jurisdiction, because her media presence doesn't seem to be her media presence isn't what brought about this prosecution. One of the victims escaping and seeking help is what brought about this prosecution. The media attention is because of the social media presence. But no, she wasn't like singled out and treated worse or treated differently because of her social media presence. And I don't see any evidence that she's been treated differently than anyone else. So let's see. Will channel revenue be put into question because the Franke children were put to work to earn it? Also, any comment on DWKT lawsuit? I don't know. Is that Do We Know Them? I don't know if there's a Do We Know Them lawsuit. I haven't seen anything about that, but I didn't know there was a Kevin Hart lawsuit. It is the holidays. So this is literally the only thing I'm covering until 2024. The channel, it's my understanding, has been taken down. Could the children sue for the revenue from the channel civilly and go through that down the road? Maybe. But I don't know. So maybe, but I don't know. There's a lot of could there be this, could there be that down the road. This was going back to our last conversation. You get behind the wheel knowing the risks. You have to prove that somebody knows the risks. So there's generally that goes to proving that people have acknowledged them when they get their driver's license or taking a class, or if they've had prior DUIs, they are read a waiver stating that they know that they could be charged with murder and stuff like that. But you still have to prove it. Cause law. World According to Briggs said, I've been watching you since the bar at Vid Summit. Sorry if I insulted you. World According to Briggs. I don't know what happened. Was I insulted? Probably not. But I was also drinking. So, hi, good to see you. Victims could bring civil cases to keep Jodi and Ruby from profiting from their stories. There are generally laws that limit the way that people can make money off of talking about their crimes. And there are also ways that those can be put into victim impact funds. We don't know about restitution and we don't know about what that will be, but the prosecutors can ask for that. Karen said the prosecutor said they were looking at they were looking. the prosecutor did say that there was room to evaluate the fact that aggravated child abuse is a second-degree felony. And that is something that needs to be evaluated within their jurisdiction. Regarding the morality legality question, everyone needs to watch Man for All Seasons. I give the devil the benefit of the law. I don't know Man for All Seasons. I'm here today for my birthday with Emily. Melissa, happy birthday. To everyone saying for everyone saying Merry New Year's, Law Nerds. Thank you. Runkle covered the Do We Know Them lawsuit. It's wild. Okay, I will go check out Runkle's coverage. Huge love to the mods who were like, we're on vacation. The mods were like, we've got this. Debbie, said my birthday was on the 15th, and for the past 2 years, I've been gifted memberships around my birthday. So happy birthday gifts and welcome to all the new Law Nerds. Debbie, I'm so glad. And thank you to all the new members. Welcome from all the very, very generous gifted memberships from Eric and B2 and everyone else who gifted, including Call Me Gray and all the new people gifting memberships. Thank you. Winter Break Emily is giving all the joy. Winter Break Emily is glad that these victims aren't going to have to testify. Mm-hmm. Very glad. Very, very, very glad. I'm very, very glad. That is the thing I am happy for in this case. On February 20th, we'll be able to case close this case and we will be done. And I will not be mad about being done with the Ruby Franke Jodi Hildebrandt case. I will not be mad at all. So, done. Ray Phillips asked a question that many, many have asked. I've sidestepped. No. The most they could ever receive under any circumstance is 30 years. The minimum they can receive is 4 years. These are second-degree felonies. They are not eligible at all. And I don't know the status of Utah's death penalty. I believe they have a death penalty because I believe that the Corey Richens case is a capital case, but I would have to look. Stephanie asked, can they still file an appeal? They have a very limited time to appeal their plea, and then they have a very limited time to appeal their sentence. So not really. They can appeal their sentence, but it's unlikely. So what's next? I saw another question. What's next on the list for the Law Nerds? I will be covering that in my 2023 year in review and 2024 looking forward. Also, I don't have my list in front of me, and I will leave something out. So I think Corey Richens is it is a capital case. I don't think the prosecution has said one way or the other, but we will need to circle back to Corey Richens in the new year because Lordy, that case. Will Jodi get more jail time than Ruby? I would be surprised. I won't be okay, on my scale of surprised, I will be least surprised if they get the same amount of time. I will be most surprised if Jodi gets more time than Ruby. That's my scale of surprise. So, Darius, I did cover the Young Thug case. I've got a podcast episode on it. And then the case had like another half a day of testimony. And then one of the defendants was injured and then they went on break till next week. So there's not much going on in it. We have a lot to cover at the beginning of the new year. There's a lot of stuff going on with Courthouse Becky that we will cover at the beginning of the year. I will swoop through into the member spaces and ask what you guys want to see covered at the beginning of the year so that we cover what you are most interested in. But today there is a new podcast episode if y'all want to listen on the audios, not on the videos, just on the audios. And that's it for the year. Law Nerds, I'm going to roll. We've been doing this for 2 hours. Are Ruby and Jodi just being sentenced? No trial. They both pled guilty to factual basis pleas, and they agreed to go to prison. So on February 20th, they will be sentenced. So, Gail, I can answer this question. Nobody knows if the custody is done yet because nobody has said if the custody is done yet, and all of those proceedings are sealed, as they should be. Loretta, courthouse Becky drama has become my favorite type of drama. So yeah, we're definitely not done. I haven't kept up. I've really been trying to be on break, but you guys know how much I love Kevin Hart. Like anytime I have an excuse to talk about Kevin Hart, I'm going to talk about Kevin Hart. Yes. I have no idea what that situation is. I had no idea that was happening until the chat told me. I will ask in the member spaces, and we will put together a docket. I've got to catch up on Idaho. I hear my family. I've got to catch up on Idaho. I've got to catch up on Corey Richins. We have a couple criminal cases ongoing. We have a lot of civil cases that we're behind on. There's a winery, the Brad Pitt winery case we are way behind on. So there's a lot. There's a lot. There's a lot to catch up on in the new year. And then we'll take a look at what trials are coming up and what's going to be televised and what's not. And of course, we'll take a look at some of the things that are interesting to you and interesting to me. We'll circle back into food court at some point. I'm sure we will. What else? And then I will cover that in my 2023, 2024 in the members' spaces. Debbie says, Emily needs a research intern. I'm working on it. I do not have a researcher at this point. I am working on it. I do all of my research. But I am working on that. I have thoughts, but we had a lot of other business stuff to do this year. And that has been at the bottom. Keeps getting pushed to the bottom of the list. Getting the app out in 2023 took a lot of team effort. So the app was our absolute priority at the end of 2023. And we have some stuff coming to the shop early 2024. So we have a lot. So we will see. Brian asked, is the Idaho house being demolished tomorrow? We will cover what goes on with the Idaho house back and forth. But the university said they weren't going to do it till the end of trial, and then trial got pushed, and I don't know what they're going to do. But there's been a lot of argument over it. So you're always welcome to join as a member. I know a lot of you guys are like, I'd be willing. Here's the thing I've learned about. I had a lot of law clerks as an attorney. I loved my law clerks. I had great law clerks, but sometimes it's much harder to teach someone your brain processes. So we've had a lot of other things that we have to get off the docket first. Joe asked, wait, Joe, where'd your question go? Damn it. I keep trying to click it. The chat goes like this, and I try to click it. It goes like this. Joe said, isn't the Idaho house a crime scene still? No, it's been cleared. It's been cleared a couple of times, and they went back in and did new scans of it, but they said they were going to hold on to it till after the trial. And I think it's probably a biohazard at this point. And it's not at all still needed as a crime scene. It's also, they can't do a jury view there. I talked about this ages ago when it came up last time that it was supposed to be demolished, and then it wasn't. And then they went in and did new scans. After they did full 3D scans of the house, I don't think there's much they can do. Becky said, as long as you don't use Reddit for your research. I don't. I just go to here's how I do my research. Where is my list of cases? What does the docket say? And then I pull the new documents. Octo, you're supposed to be resting. Get your butt back in bed. He's probably still in bed. So I think there's nothing left that can be done with the house, because there's nothing more that's going to come up after they did new scans of the house. So I imagine they have full video and full 3D scans and models that they can make. The jury can't go into the house in Idaho to do a jury view. The house has been substantially changed and internally dug up while they were investigating this case. So a jury would never set foot in that house anyway. So they should have everything they need from the house. And that should be it. Oh my God. Hey, friend. Hey, it's good to see you. We're talking about crime things. No ChatGPT for research. Only if I'm making ChatGPT write a song about law. What did we make ChatGPT write a song about in 2023? Was it the rule against perpetuities? It was actually pretty funny. Ray said, I'm looking forward to the Donna Adelson trial. Same. Donna's wild. Donna is wild. Absolutely wild. Absolutely. Everybody's here today. We should just keep streaming. Angie, it's good to see you. That's true, Octo. I didn't say you weren't in bed. The rap against perpetuities. It was pretty funny. I enjoyed it. The ChatGPT rap about the rule of perpetuities is a core memory. It worked really well. I think I would use it as a study mechanic if I was studying now. So I saw somebody ask about Sarah Boone. I don't honestly, y'all, I don't even know if that case is ever going to trial. If it goes to trial, I'll cover it. I don't know if it's going to happen. How do things like the Idaho situation affect the homeowner? The house was turned over to the university. I don't believe the house was originally university property, but it is not good when you are a renter and something, or you are the homeowner, landlord, and something like that happens at a rental property. It's really tough. But I don't know if the university bought it for them or what happened, but I know that the current owner of the house is the university. So the university gets to make that decision. Sarah just keep streaming. We have to wrap up. So if Sarah Boone ever goes to trial, yes, I will cover it. Let's talk about the Adelsons and hang out more. I have nothing pulled up on the Adelsons. Will you be covering Donna the whole trial? Oh yes, we are invested. We are absolutely invested. Corey Richens doesn't have a trial date yet. So when will we cover Corey? Whenever Corey goes to court, we will cover Corey. Any update on the TikTok case? Not today, because I did not pull it up. I thought Great Dane Mom, that's what I thought that it was gifted. We'll see. But that's what I remember reading. But again, I haven't looked into it today. I'm in Arizona and I'm looking forward to the Lori Vallow. Yeah, Lori Vallow has that next trial in Arizona. That one I might cover. Ashley B, will you be covering the lawyer Jeanette suing the Do We Know Them podcast? The chat told me that Runkle covered it, so I will go watch Runkle's coverage of it and see if we need to cover it. And then if we need to cover it, I will cover it. Can we rewatch Depp trial highlights together and laugh? In our member spaces, we probably can. I have been very tempted. There is like one day of testimony that I missed of the Depp trial, or a day and a half, because I was traveling and I was at a friend's conference. And I might just go do it. But I might cover the Vallow Arizona case. So we will see. I know we will get back to courthouse, Becky, I promise. There is so much. Brian Enton said it was gifted. Thank you, Linda. I remember reading that it got to the university. I wasn't sure how. I don't know how much insurance covers that. Like, I don't know how much insurance would cover your house becoming a crime scene to the point that it's unusable and has to be demolished. Questions I don't know the answers to. What's Alika said, Brittany? Yes, I am well behind on Brittany, and it's going to take me a minute to catch up on Brittany, because there's a lot of documents. So yeah, we'll get back to texting Judge. Is Brittany going to trial? So the financial stuff is supposed to go to trial in May. Brittany will not be there. It is between really her attorneys and then their attorneys. It is not going to be a trial while Brittany will be sitting in court every day for. It is still over the 12th accounting. So, would you ever consider doing a fun Q&A? That's generally what we do in our members only spaces. Though I do still need to watch Legally Blonde with Runkle. And at some point we need to talk about the legal ramifications of Grandma got run over by a reindeer. But with all of it, Lawnards, it is time to say goodbye, because I need to go get back to the projects we were projecting. I have been like cleaning out my office. I am taking everything off of all of the shelves to dust and clean everything. It is that type of year. I got a steamer. Emily, how much cleaning content do you watch on the internet? Too much? Because I thought a steamer was a good idea. So I got a steamer. We are going to clean all of the things. So that is the projecting I am in the middle of projecting with. So I am going to project all of the things. So we will see an updated, but I will not be streaming. I'm going to be tearing apart my office some more. We've got some new cup storage. I have some posters I pulled out that need to be framed. Like we are We are organizing the office. Dr. B has been doing all the things. Lindsay is like, do not steam clean the electronics. No. I need to clean the carpet. I need to clean the shelves. It's time. It's time. It's that time of year where I just want to clean all the things. I want to, the windowsills, all of it. We are going to steam all of the things. I'm very excited. So that's the projecting. That is the projecting I am in the middle of over at the Baker house. So, and the kids are like, everybody's on board. It feels, some people do this in September. I tend to do it in September and in the new year. Like September tends to start it off with or August really with the beginning of the school year. But then the new year always feels like the right time to kind of reset. And this is the time when I just reset. So things get cleaned. It's just, I know people do spring cleaning. I definitely do a reset of all of my spaces to get ready for the new year and all that's to come. So that's what I'm going to do. So it feels like the right time to do it. So it is the time. I'm reorganized. I have too many projects going on because ADHD, but it's like, I want to do this. I want to do that. And with all of it, we will do the things. When you polish the floor, we're definitely steaming the floor later, but the tree will get put away before we do that. So when we put all the holiday decorations away, that's when we're going to clean the rest of the house. But I'm going to be cleaning all of this. So the reset for the new year, I will have some stuff for the members. If you want to keep up on everything we're covering in 2024, the Lawnerd app, it's free. It's a project that we love. It is what keeps you in the loop. So for all of you that were like, I didn't know you were streaming, the Lawnerd app will keep you in the loop. All right, y'all. Merry, Happy New Year. I will see you in 2024. Let's everybody, let's just pray that the court keeps all the fuckery to a minimum for another couple of days. It's Wednesday. Let's just hold it together until next week, and we'll be back in 2024. You guys have a safe and happy new year. Thank you, Lawnerds. Thank you for being here. It's time to get into all the stuff new year. We're getting ready. So thank you for being here. Thank you for being Lawnerds. I enjoy being here with you. It's why we stream today. Thank you. Thank you to my amazing team, all of you at Team Baker. You guys make this possible. To my producer, Miguelina, thank you. Thank you. Today she's like, yeah, we're riding. I'm like, we ride. And the mods, you guys, we couldn't do this without you. It truly is a team effort. And that includes you, chat. It's a team effort, chat. And you guys keep it amazing. So thank you for being here. Truly. Everything we do is for this community, and so we can be nerdy together. And that is what we're going to keep doing in 2024. What the community wants to talk about, we will be talking about. And with that, I will see you guys in the next year. Thank you. Bye. You can stay up to date with everything I'm covering and fast notifications on our free iOS and Android app at lawnerdapp.com, or search the App Store for Lawnerd. You can also follow me around social media, and don't forget to check out my podcast, The Emily Show, with quick bits dropping every Monday, summarizing everything I do here on the live streams on Tuesday and Thursday for when you just have time for the quick bits. Thanks for being a Lawnerd.